The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Please be seated. We'll call the third case on this morning's docket, 106093, State of Kansas versus Lewis.
May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Tony Lewis. Justice Lukert, if you would please reserve 2 minutes rebuttal time.
2 minutes.
Thank you.
Thank you.
There are several issues raised in Mr. Lewis's brief, a lot, and I could talk about each one for about 20 minutes. But today I'd like to only focus on issue 1, the district court's response to the jury's question. But before I do that, I wanted to quickly address Mr. Lewis's 5 life sentences. We believe those should be vacated and remanded for resentencing. Under Trutloff, he committed this offense in 2009 before the before the statute was changed, and we were operating under 2 prior conviction events. Here, we don't have that. We only have 1 prior conviction event, the Geary County case. So we believe that his 5 life sentences therefore don't meet what would be an aggravated habitual offender. And also we have Turner, which came out, and I filed a supplemental brief on stating that the 2 rape sentences would fall under persistent sex offender. So now that I've addressed the 5 life sentences, which we believe should be remanded, I'd like to jump to the first issue. Now, there are 10 charges filed against Mr. Lewis. There are several victims. The jury goes back at 11:15. The jury retires to the jury room. And I apologize for going through the facts, but I think it's essential. 2 hours later, the jury asks the court, can we find the defendant guilty on all but 2 counts? The court says yes. 2:40 goes by, 2:40, so we have an hour and 25 minutes. The jury asks, if we're unanimous on all but 2 counts, are those 2 counts going to be thrown out, or what will happen to those? And then parentheses, we are not unanimous on 2 counts, only by 1 vote nay. The district court then receives input from the parties. Now, this is where we disagree, I and the state, about whether we have invited error here. The state, well, I think the answers probably would be the county attorney's decision. They could be retried, or if he felt it was not necessary to pursue, they could be dismissed, or it'd be up to the county attorney to make their decision. The defense gave a really simplified response of, I would just say something like, you should not concern yourself with this issue. Hearing those 2, the court makes a 180 and does something quite different, and does something more egregious than an Allen instruction. He tells this jury that is hung, I'm going to refer them to instruction number 3. Your duty is to determine if the defendant is guilty or not guilty. The disposition thereafter is a matter for determination by the court. What happens after that is quite telling. At 4:30, we don't have a jury that is hung on 2 counts. We have the jury doing its duty that the district court said it should do.
And counsel, where did the defense counsel object to what the trial court was about to do?
The defense counsel did not object. The defense counsel gave a different response.
That was prior to the court saying what it is they were going to do.
Correct.
What the court was going to do.
Right.
And then after that, the defense counsel says nothing.
Right. Now, the contemporaneous objection rule applies to evidence, not to jury question. And so I would argue that we are not procedurally defaulted by that rule. We do have a defense attorney giving a different response from the court. And as I cited under Jones, if you give a different response, this issue is preserved for review.
That's a Court of Appeals decision, if I remember right.
Yes, it is. It is a Court of Appeals decision. Had that app next to it, so that hurt me. Can this court consider this issue? The state's argument is that this is invited error. argues that the defense counsel invited this error because the court gave the same answer that defense counsel gave. Now, as many times as you could look at it, that's not the same answer. She was given a very simplified answer. Don't concern yourself about it. The court told the jury they had to reach a verdict. Its duty was to reach a verdict. And I've cited Bruce and Kramer distinguishing those two cases that this was not invited error. Here, no matter how liberally construed, the jury was told of its duty, and there is an evidence that the defendant acquiesced, as in, I have no objection, that's fine with me, Your Honor. We don't have that here. Now, why this is error seems quite clear. It is, first, it doesn't answer the jury's question. It tells them about a penalty that they shouldn't be concerned with. That's from Pick. It pulls up from Pick, and that's really relating to what the sentence should be. So we would argue that's a misstatement of law because the instruction is incorrect. More importantly, it's coercive because it's a forcing type instruction. Here, the court is forcing the jury, a nay person who's holding out, and telling them your duty is to find it guilty or not guilty. So after the jury reports its failure to reach a verdict, it's telling them they have to reach a verdict. And it's instructing them, so I would say this would put more pressure on that nay juror to reach a decision, and allows the other jurors to put pressure on that nay juror. Look, what is our duty? What is our one role here? It's to find the defendant guilty or not guilty. It's also misleading. They're never told that they are free to not reach a verdict. They're never told that. They're never told, don't worry about it. They're told, don't worry about the sentence. And in my brief, I've given you the imagination of the nay juror, and I don't want to repeat that here, but I've basically given you a walkthrough of what this nay juror must have gone through after saying, I'm not convinced. The juror foreman saying, okay, we'll ask the judge what the question is, and the judge coming back and telling them you have to reach a verdict. It's even more direct than the Allen of a second trial will be a burden on both sides.
Were there convictions on all counts?
In this case,
Uh-huh.
9 of the 10.
Okay, so presumably if they were hung up on 2 counts, then when they came back, there was 1 acquittal.
Correct. But no 8, we find him guilty of 8, and we're not sure about the other 2. They all did what the judge said. They reached a verdict. We would argue that there is error here, even under constitutional harmless error or statutory. We would argue it's hard not to see prejudice when the jury did not remain deadlocked, and they did come back with the verdict. We argue that this did affect Mr. Lewis's substantial rights. That's really my argument in a nutshell. We have a lot of other issues, like I said, but those I think would take a lot of time to get through. If this court has any questions about those other issues.
Any questions? Thank you, counsel.
Thank you.
May it please the court, Presiding Chief Justice Lukert and counsel. The state would disagree with Ms. Pickering's description of the court's response to the jury questions. There were 2 jury questions regarding the deadlocked jury. The first question that came back from the jury was, can we find the defendant guilty on some counts and not reach a verdict on others? And I'm paraphrasing. Can we find the defendant guilty on all but 2 counts? Trial court did not tell us where the jury stood, but responded to that jury question, yes. When the jury came back with the next question on what would happen to the 2 remaining counts, indicating that there was 1 holdout juror on 2 counts. Court asked with both the state and Ms. Wacie Seaton, who was the defense counsel on the case, for our input. I responded, and again paraphrasing the deadlock jury instruction, but that it would be up to the county attorney whether to pursue those charges, and I laid out in a brief, so I'm being somewhat redundant, but it would be up to the county attorney to decide what to do with the charges. We could either retry them, or we could decide to dismiss them. It would be up to the county attorney, and I would agree with appellant's brief. I do think that would have been a correct answer. However, defense counsel responded, and her answer was, I think you should just tell them they shouldn't concern themselves with that issue. And the records never reflect whether it was instantaneous or whether the court considered it for a few minutes, but you do see the court's response where the court says, I'm going to tell them basically the sentencing portion of the instructions. Your duty is to consider whether the defendant is guilty or not guilty. That's the instruction that they were referred to. There was no objection by defense counsel. We believe that that instruction that the court referred them to, certainly more closely in principle, followed defense counsel's suggestion as opposed to the state's suggestion. There was no objection when the court said that he was going to refer them to the disposition instruction. There was no objection by defense counsel. We believe under Adams that at a minimum it is acquiescence to the response given to the jury by the court. We would also take the position that it's invited error. Defense counsel could have offered the court to give the instruction, the deadlock jury instruction. That was not done.
Well, wouldn't invited error be really more akin if they suggested this instruction and now claim error with giving it? Isn't that more an invited error rather than requesting a different answer and now
probably
complaining that they didn't object?
I couldn't disagree with that. In our position, we think the acquiescence is by far the strongest argument.
And the acquiescence in your mind is what's invited error?
Yes, we believe that is the strongest argument under Adams.
But there is a difference between disposition after guilty or not guilty and disposition after mistrial for hung jury. Wouldn't you agree?
Certainly.
Yeah.
Yes.
And what was given is don't be concerned about the disposition after you've performed your duty of either guilty or not guilty. So it really didn't answer the question of what happens when you have a mistrial for hung jury. I mean, it's close. It's close. Don't be concerned with stuff you're not supposed to be concerned with, but it's telling them don't be concerned about what happens after you find guilty or not guilty, not what happens after mistrial.
It didn't answer the jury's question. And I don't, not to keep harping on the same argument, but defense counsel's suggestion did not answer the jury's question either. Her suggestion, you don't concern yourself with that issue. Well, obviously they are concerned with that issue. There were several other issues raised in the brief.
Can I move you over to prosecutorial misconduct, because that's one that's bothering me. It seems like the comments about victim dignity and you're going to get this case to go forward was awfully pervasive, and since you were trial counsel, that was clearly a calculated thread throughout your closing argument. Would you not agree with that? I mean, you said it an awful lot for it to be just a spontaneous kind of statement is what I'm getting at.
I don't prepare closing arguments with themes, but this rape case with these victims and under the circumstances probably was one of the most psychologically brutal rapes that I've been associated with. I tried to tie my comments to the evidence in this case. The first victim that we put on was told after she undressed to sit down, stand up, sit down, stand up, before she was forced to perform sexual acts. Her children were threatened. Basically told she couldn't go to the police because the defendant knew where her kids went to school and where she worked, and that he'd been sent there and he followed her home from Junction City. In this case, the first VDD, the victim, wasn't forced to pay for being raped. But the demeaning nature of these several acts that the state laid out in this case, and I don't want to be crass, but, telling victim AG, the Blake May victim, that, you women all aren't shit. Forcing one victim to kiss him, forcing another victim to make sounds like she liked it after she had been forced to go to an ATM at gunpoint, after she had been forced to take money out of an account that she didn't have. The comments are there. This is always awkward because I don't want to sit here and say I didn't do anything wrong. At the time, on reflection, when I saw Ms. Pickering's brief, my response, oh my God, what did I do in this case? And then you try to take yourself back to the evidence that was presented. I would argue that some things could have been said better. Maybe I should have just focused on the evidence in its entirety, because there certainly was enough examples of brutality, either physical or psychological, that I could have made my point just by going over the statements that the defendant made to each and every one of these victims. These were psychologically devastating crimes, and I was trying to purvey a point without, frankly, walking a jury back through each and every detail, or the important details of these crimes. I believe there was overwhelming evidence in this case. I don't believe there was ill will, and I don't believe it was gross or flagrant.
Well, the ill will and the gross and flagrant kind of gets us to the notion of what have we said in the past and whether professionals can be professionals even when the facts are terrible. And I think the heinous nature of the crime doesn't lower the bar of professionalism, and so that's the concern, that we're sort of down to our standard of whether this is reversible prosecutorial misconduct, because you've conceded that you shouldn't have said several of the things that you said. I think even if you didn't concede it, we'd probably be there anyway, or at least I am. So now we're really down to whether this is reversible error given the nature of the evidence and the strength of the evidence of your case. So do you want to address that specifically so that we can get to that point?
Certainly. With regard to the rape and aggravated criminal sodomy of first victim, VD, we had her ability to identify the defendant, although he had a scarf that he tried to put over his face. When she first opened the door, she got a clear visual. His DNA was in her underwear. And I'm referring to counts 1 and 2. With regard to counts 3, 4, 5, and 7, we have the DNA from what's been described as a Jason mask, the victim's DNA that was on that mask. During the search warrants, we recovered the clothing items that were described by the victims. There were different facial masks that were worn. Those masks were identified by the various victims. We had the firearms. One was an airsoft pistol, one was an actual firearm that were recovered during a search warrant. In addition, we had 2 vehicles that were involved in this case. One was a Ford Focus, a blue Ford Focus. The other one was a white Dodge. Both had been described by various victims in the 2 counties. The white Dodge belonged to the defendant, but we also knew that he was driving the blue Ford Focus that belonged to his roommate, Jonathan Jenkins, because we found a speeding ticket in the vehicle that tied the defendant to driving his roommate's blue Ford Focus. And we didn't call him for trial, but at preliminary hearing, we knew that he established he wasn't driving that blue Ford. The defendant was. So we had vehicles, we had the mask, we had the clothes, the dark attire, pants, gloves, masks that were used, DNA, and without closing argument, I believe a jury would have reached the verdict that they reached in this case.
As I looked at the evidence, I was the victim ALT, which is your ag assault conviction, and then the acquittal on the ag kidnapping, I think
Correct.
it was. That evidence was a little less direct. You didn't have any DNA. You don't have an identification solidly from the victim. So what evidence on that particular conviction, the ag assault conviction, do you think could overcome the comments made during closing?
We had the firearm that she identified, and we had a black size 12 tennis shoe that was located in her vehicle. Her vehicle was the one that was driven, or we allege was driven by the defendant, Tony Lewis. But she identified the black mask with the eye holes that were handmade or cut out in front of the jury. And we knew that the defendant wore those size 12 shoes because we found them during the search warrant. And I know I'm out of time. With regard to the confession we've responded to in our brief, the admission. We don't believe that the defendant was in custody at the time that Detective Lewis gave him the 10-minute interview. We set out the Jones factors, and applying the factors that were established by this court or announced by this court in State v. Jones, we believe that it would show that that 10-minute interview was non-custodial and had not reached the accusatory stage. The identification, we believe, is good as well. And with regard to the sentencing issue, the state would acknowledge there are some issues with the aggravated habitual finding under Turner. But if there are no more questions, I know I'm out of time.
With regard to that custodial nature, the defendant was ordered to that particular place by a superior officer, correct? Am I recalling? He was told to come to a certain place by a military person that was of higher rank.
Chain of command, yes, I believe that's true. I don't.
And then when he got there, he was directed to where he was to go by the military individual, correct?
Correct. And I believe the transcript would show that Agent Anderson said any witness who goes into that building, victim, witness, whatever they may be, goes through the same process.
I'm just trying to look, and where I'm coming to is our cases talk about the objective, reasonable person analysis with free to leave, and does that when we're talking about the reasonable person, are we talking about a reasonable military individual of lesser rank than the person that put him there versus a civilian? Do you understand where I'm getting at? Is if I were told by a captain to go someplace and sit, I would sit there until I was told I could leave when I was in the service. That's what I'm asking is how do we factor that in to our analysis? You understand what I'm trying to say?
I do.
It's all driven by a reasonable person feel free to leave.
And you're under the discipline of the Army that says you need to go there and talk with these.
You need to go in there and sit down.
Yeah. Well, state's responsibility under a totality of circumstances, that may be a factor, but when you look at the nature of the interview, you don't think by any means it could be described as an interrogation. I mean, the closest we got was you go to any bars. Otherwise, that interview was small talk, and it was only 10 minutes long. And he wasn't even confronted with the fact he was a suspect in rapes.
And the other physical factor is, as I recall, that you have to surrender your wallet and keys when you go through this process. Is that true with anyone who enters that?
That was my understanding from the testimony of Agent Anderson, was if anybody who goes through there would have to surrender those items.
Any other questions? Thank you, Counsel.
With respect to the interrogation, I think it's quite clear that he was not free to leave. He was ordered there. When he fumbled his way and appeared to be lost, he was told by his superiors, "Come follow me, I'll take you to that place to be interrogated."
What did he reveal that would have changed the outcome?
That he went to the clubs that he went to the same nightclubs where the victims went to and were followed from. In my brief on page 29, Mr. Lewis told the detective he had been at the pool hall the same night that ZG was sexually assaulted, but he only stayed for 10 minutes. And then at trial, that same detective uses that statement against him and says that he found Mr. Lewis's story of only being at the nightclub 10 minutes implausible. So that builds the state's case that Mr. Lewis was at that nightclub, that pool hall. And it actually builds the state case of the fact of the jury's told, well, once we found out he went to these same places, that's when we brought in and had him Mirandized. He had to empty his pockets and hand over his personal belongings. Page 28 of my brief. He gave up his car keys, cell phone, and wallet. Later on, one of the, I think it was one of the officers said, Agent Anderson testified that if Mr. Lewis had been terminated, his interview with Detective Lewis, Mr. Lewis would not have been free to leave because the CID would have wanted to talk to him. And again, that's in my brief. So we have a custodial interrogation here, one that did affect the trial, and we believe that those statements, the first interview tainted the second one because no Miranda warning was given to an officer ordered to report there. With respect to just jumping back to, I'm going to go back in order, I guess 3, 2, 1, issue 2 on the prosecutorial misconduct. These are horrendous facts. And we're going to have them in all these cases. But when you have horrendous facts, we ask the jury just to be told those and not to be told about the dignity of women, not to be told how the victim's day was today, not to be told that their rights were violated, not to be told that Mr. Lewis felt entitled. That could be said in so many cases, and certainly should have not been said here. I believe opposing counsel was correct that we should have just let the evidence speak for itself.
And if the evidence speaks for itself, and I'm not one that, because a case is strong, that you get greater permission to commit misconduct or anything like that, but how do you overcome the forensic evidence in this case?
It is quite an uphill battle. DNA of the found on the victim's underwear, but I wanted to point out to ALT's testimony on the aggravated. Again, see, her testimony is still her testimony.
I mean, this is not a consent defense type of case. How do you overcome that evidence?
About the DNA? No,
Yeah.
It's hard to overcome that. However, the DNA evidence was for not all the victims.
No, only ALT didn't have DNA. And
Right.
And all you've got there is an ag assault.
Right. So you don't have DNA there. You don't have DNA found for ALT. I don't
You do have
think
a
so.
size 12 shoe.
Yes. But when you have a jury instruction, and I'm going to go to cumulative error. And when you have a jury instruction that is response to a jury where they're deadlocked and told you have to reach a verdict, then you have a jury being told it needs to defend the rights of women and how they were violated. Then you have an interrogation that we believe was custodial. We believe this all adds up to cumulative error. We ask this court to reverse and remand for a new trial. If not, in the alternative, to vacate his 5 life sentences.
Other questions? All right, thank you, counsel.
Thank you.
Court will take this case under advisement.